we welcome you all in our pursuit to bring the knowledge of law and other professional knowledges on the platform that we now, in the today's language, we call as the virtual platform. And in the virtual platform, the first and the paramount thing would be that since there's no direct eye-to-eye connection, so a speaker and a person with immense knowledge can only make people connect. And in that pursuit, we have always been looking upon the speakers and who have been kind enough to accept our invites and share the knowledge. And then in that pursuit, I can vouch upon that amongst us, we have Justice S.D. Anand and Justice H.S. Bhalla, both former judges of Punjab-Haryana High Court. Both of them have immense knowledge, and both of them have a common factor that they dissipate the knowledge while speaking that you are automatically attracted. In our High Court, they were famously known as magnetic and charismatic personality. And I'm quite sure that the persons who will hear them, not only on this platform, but also on the Facebook, since we are live on that they will actually feel that when we have called Justice Anand, and when we had called Ma'am Pinky Anand, fortuitously I feel that whenever the name Anand comes, automatically the word Anand comes to the mind. And same is with Justice Bhalla. It was once you appear, one used to appear before the courts, one was always feeling that stress of the first at the opening statement would never be there. Be that as it may, Justice S.D. Anand, after his superannuation, was the member of the Central Administrative Tribunal, and he's a avid writer as well as speaker. And same is with Justice Bhalla. He's an avid speaker. And Justice H.S. Bhalla, as we all know, that his judgment in respect of Mr. Late, the former Chief Minister of Punjab, Bhyan Singh, is well known. And that is just one of the star highlights. Otherwise, both their judgments, both the judges' judgments are immensely popular. And one thing amongst both of them, it's a very rare connection, that both of them used to write very crisply and used to, actually what we have heard, the word of dispensation, the justice would always be dispensed in a positive manner. And the lawyers and the litigants were always happy. And what I initially said at the first instance, though Justice S.D. Anand carries the name of Anand, but when we appeared in both the courts, we always had an Anand that whatever we had thought of, we in fact got more than what we thought of, we could get it. Justice S.D. Anand, though we have shared in the invite, has written various books which are critically acclaimed. That is The Prism in Mind, Living in Vestibule, Ascension's Dilemma of Justice Delivery System. So the fact that he has written on the justice delivery system, and today's topic, which is discussed not only amongst the professionals, students of law, in different academics, law commission, etc., death penalty, retention or its dispensation. So we thought that let's request the judges who have that immense knowledge to share their knowledge on this aspect. First, I would request Justice H.S. Bhalla to give his insights. Justice Bhalla is there. And Justice S.D. Anand. I will just check it out because probably Justice Bhalla is not on the platform. I will just give him a call.
I think we can save time.
Yes, you can share your knowledge. Meanwhile, I will just get connected with Justice Bhalla because he was there.
Good afternoon, everybody. It is one of the very nice opportunities which the CLC Beyond Law has afforded to us to share our views with the viewers, to share our views about topics with which we have been dealing all along, and each facet of the topic is relatable to the very existence of citizenry, the fundamental rights, the natural justice. You see, law is something which is not brought into being in an abstract form. It is based upon the needs of the society, the need of governance.
So you have logged in. Justice Bhalla, you have logged in.
Yeah. In fact, there was some problem about the light, so now it is on generator. That is the
Right,
problem.
sir.
Okay.
I know that you will generate the energy to the right platform in the right manner.
Yeah, that's right. Achha.
Right.
So
then you can pass
should
on
I carry on?
Justice Bhalla.
Yeah.
No, sir, you can. Right, sir.
I'll continue.
Hello, brother.
Sir, just one thing. Justice Bhalla, probably your camera is slightly, you have to adjust it. So that,
Now-
yes, sir. Now it's fine.
No,
Yes.
no, it's okay.
Yes, sir. Perfect.
Okay.
Perfect.
So tell
Yes, sir.
me when I have to.
So now, I just had to make a call. Now it's 102.
Okay. All right. I'll start now then.
Yes.
Okay, brother. Hello, can you hear me now?
Yes, sir. Perfect.
Can you hear me?
Sir, yes, it's audible.
Okay. Very good afternoon to all of you. And million thanks to Mr. Vikas Chattat for giving me an opportunity to do something during lockdown period. Because we have nothing to do during lockdown, I am very happy that he has asked me to join here for this purpose. So I am grateful to him for that. Now, before I say anything on death, I would like to say something on the birth. A very happy birthday to Justice S.D. Anand. Belated happy birthday. His birthday was yesterday.
Thank you.
So on behalf of all the persons who have joined, so I wish him all the best and once again a very, very happy birthday. Now,
It's particularly important because it comes from my schoolmate.
yes. And now I go straight to the topic.
Thank you.
That is death penalty retention or its dispensation. Well, gentlemen, for the last number of years, the abolition of death sentence have been looming large over the Indian horizon. The leaders, politicians, and legal luminaries have not been able to find a solution acceptable to all. Though capital punishment has to be awarded in a rarest of rare case, yet the apex court held in no uncertain terms that the same is legal and does not violate Articles 14, 19, and 21 of the Constitution. As you all know, it is settled law that mode of executing death sentence by hanging is not violative of Article 21 of the Constitution, as it is not cruel, barbarous, or degrading method. Death penalty has been the subject of an age-old debate between the abolitionists and the retentionists. In the ancient time, the punishment of death was the only punishment for almost all the crimes. Sometimes it was inflicted in order to deter others, sometimes in regard to retribution, and sometimes to incapacitate the offender, meaning thereby that the extreme penalty of law today, which is imposed by the courts with due care and caution, was almost the rule in the ancient time. Now, from where did we get all this? The punishment of death was imported to India from the England by the British rulers. The criminal law was codified in 1854, which was amended by two commissions simultaneously. This constrained the penalty of death for 7 offenses and came into existence in 1860. All the 7 sections are still on the statute book since then. These sections are 121, waging war; 132, abatement of mutiny; 302, 305, 307, and 396. In addition to these sections, the punishment of death can be imposed under IPC for 3 more offenses, where it is imposed by way of constructive liability under section 34, 109, 119 IPC and 396 IPC. Anyhow, punishment of death is still imposable and imposed, and the accused are still being executed in spite of all the agitations. Though the abolitionists have given the name of cruel and unusual punishment, they call it as a barbaric and primitive punishment. As it is still on the statute book, certainly it must be having some merits and the demerits automatically attached to it. To my mind, keeping in view the present circumstances in our country, particularly with regard to the crime in the states of UP, J&K, and Bihar, the death penalty is required to be retained because it is the extreme penalty of law imposed by the courts. Punishment must serve as an instrument for reducing the rate of crime, either by deterring the offenders and others, or should prevent the commission of crime by incapacitating him. Now the question whether this extreme penalty of law should be retained or not. Does it enact as deterrent to the repetition of heinous crimes such as murder, bride burnings, and most of the socio-economic offenses in India? These questions have been debated over centuries. Its census is at times reached in some countries have taken the experimental measures, but as of abeyance, the rate of crimes increased and death penalty is again reintroduced in some of the countries. The most recent example is of New Zealand. As far as India position is concerned, the argument which may be valid for other countries may not be valid for India on account of the reason of illiteracy. Deterrence effect of death penalty is one of the basic arguments forwarded by the retentionists. Human being is complex and actuated not only by fear, but also by love, loyalty, greed, lust, and many other factors. Deterrence effect of death penalty cannot be seen directly, but it acts on the community in the form of moral consciousness. To my mind, public opinion is in favor of death penalty. Capital punishment is painless and humane in form and is less cruel than the punishment of life imprisonment. Because of the provisions of appeal and power of pardon vested in the president or governor, so there is no question of miscarriage of justice. India is a poor country, so it cannot and is not able to imprison all the murderers and feed them for decades. Death penalty functions and helps in avoiding popular action. Main argument of the retention is that even if the principle of abolish is accepted and time has not yet ripened in India because present day society has not yet matured for this reform and the community has not yet ripened to that stage. The next important point calling for our attention is public opinion. In the present state of civilization, before taking any step, public reaction must be gauged. Success of the step depends upon the public cooperation, and without taking the public opinion along, its implementation becomes very difficult. In cases where subsequent doubt arose concerning the guilt of the person sentenced and executed, as happened in the UK and USA, veritable waves of public opinion have set in motion, and these have sometimes provided the abolitionist movements with additional supporters and fresh arguments. Turning to India, so far no attempt has been made to collect systematic scientific data in respect of the public opinion in this matter. If judiciary gives any representation to public opinion, there are definite signs of change. In ancient times, life for life, eye for eye was the rule of criminal justice. In modern times, however, reformist thinkers and jurists have referred the death penalty is barbaric and primitive in origin, which does not go in tune with the modern day society. But in spite of all these, the case for retaining the death penalty is based on certain concepts of awarding adequate punishment to the crime committed. In my opinion, the punishment should be adequate with the gravity of the offense committed. The heinous is the crime committed by the accused. The quantum of punishment should also be in tune with the gravity of gravity of crime committed by the accused. Gentlemen, there are enemies of society who have proved incorrigible, who attack even the guardians of law and order, and thus pose a constant danger to the security and sanctity of life. These social enemies frequently disturb the life of innocent citizen, which is in order. We shall have seen recently in the case of Vikas Dubey in the state of Uttar Pradesh. So therefore, in such like circumstances, it has to be retained. I am also of the opinion that for the production of organized society, civilized community, death penalty should be preserved. As such, prima facie, the penalty of death is likely to have a stronger effect as a deterrent to normal human beings than any other punishment. In fact, no other punishment deters man so effectively from committing the crime as does the punishment of death. Deterrence is the main object of the punishment. In criminal justice, a punishment aims to punish the offender, to deter others from committing the crime, and to protect the society from criminal activities. Everyone who commits murder wants to escape from the sentence which he has earned. So if there is no such sentence, in all likelihood, the fear that comes in the way of the people committing murder will be removed. In order to reduce such crimes, there should be no abolition of capital sentence for the maintenance of law and order in the country. Capital punishment is necessary because life and property should be made secure. By the abolition of capital punishment, we'll be giving a sort of right to kill without punishment. Therefore, abolition of capital punishment may do harm to the country than we can visualize. Keeping in view the condition prevailing in India, abolition of death penalty is very dangerous and can be detrimental to the interest of the state. So long as the crimes are there is no reason to abolish the capital punishment. No doubt, we must follow the ideal of hating the crime and not the criminal, and thus to end up with the crime and not criminal. But this view too must be seen in the light of atrocities, injuries, losses, and innumerable mental traumas undergone by the victims of crime. And one must not forget that death penalty may not be workable in the case of hardened criminals, but he has really deterrent impact on the first-time criminal world. So in spite of abolishing the death sentence, we must keep an Indian penal code for strong and deterrent impact upon the criminals and to maintain the faith of the society by assuring them that the wrongdoers will not be spared at all and will be dealt with stringent laws, providing stringent and more harsh punishment and thus providing the teeth to the criminal laws. In order to conclude, I would like to observe finally that the capital punishment has its impact in number of ways. on the administration of criminal justice. The movement for the abolition of capital punishment is a very old one. There is a change in this respect, which explains the decline of death penalty in states and that have crept in law. We have also seen that there is a general trend towards the number of offenses punishable with death. So the death penalty must be retained in criminal law and should be applied in the rest of their cases. Now, with regard to the other aspect, with regard to the abolition. So before I say something, even it can be argued the other way side, I have a practical experience on this, and I am putting that practical experience before you gentlemen, and then you tell me whether it should be retained or not. With regard to this practical experience, when I was Session Judge Bathinda, a death sentence was awarded by me, and thereafter I was transferred to other places, and finally I was elevated and I came to the High Court. And after about 2 years, I went back to Bathinda as inspecting judge. I inspected the central jail. I found that man there who was given awarded death sentence by me. And the superintendent jail told me, okay, sir, he wants to say something, wants to request something. I said, all right, let him do that. So I asked him, मैं क्या बताओ भाई क्या कहना है आपने? कहता जी मेरी एक रिक्वेस्ट है भी तुसी मनु फांसी दिती सी। मैं क्या बिल्कुल ठीक है। ते मुड़ के सुप्रीम कोर्ट ने इन्हू जी लाइफ इंप्रिजनमेंट करती। मैं क्या ओके फाइन। पर कहता हुण तुसी हाई कोर्ट चले गए हो। मैं क्या बिल्कुल ठीक है। ते मैं चाहना जी मनु तुसी फिर फांसी दे दो। मैं क्या क्यों? The God has given you another opportunity to live. कहता नहीं. Every day in the morning I get up and I feel that I am being hanged by neck till my death. And I pray to Almighty to meet my edge of doom at the earliest. So what I mean is from this, that everybody says that this death penalty would be deterrent. I say no. If you have to argue on the other side, a person who has been awarded life imprisonment till life, he dies almost every day while he is in jail. As soon as a person is hanged after the execution of the death sentence, if a person is hanged, he is relieved of his sin immediately. He doesn't have anything to think about it, that I have done something wrong, I have committed such a sin, meaning thereby that he has no time to repent on it. And if the death penalty is abolished, and if he is awarded life imprisonment till his life, till he meets his edge of doom, till his natural death, then he, to my opinion, dies every day and is a more deterrent for him and for the others. Now the other way around, I will give you a data of 62 years, right from the President of India, Dr. Rajendra Prasad, in 1950 to Shri Pranab Mukherjee, 2012, 62 years. During this period, 437 persons were awarded death sentence. I mean, in 437 cases. And number of mercy petitions which were accepted in these 62 years is 306, meaning thereby 131 were rejected and the people were executed in only in 131 cases. Again, number of so many people got life imprisonment and they were not hanged. So this is the state of affairs. And when this is the state of affairs, then even if the death sentence is abolished, I think it will be more good for the criminals. They will learn more lesson, and that is why I feel that it should be abolished. It should not be, it should be abolished. And moreover, there being no legislative policy or principle to guide the court in exercising its discretion in this delicate and sensitive area of life and death. The exercise of the discretion of the court is bound to vary from judge to judge. What may appear as special reason to one judge may not appear to another, and the decision in a given case whether to impose death sentence or not, or let off the offender only with life imprisonment, would depend upon the judge called upon to make the decision. The exercise of discretion whether to inflict death penalty or not depends to a considerable extent on the value system and social philosophy of the judges constituting the bench. Therefore, to my mind, even if it is abolished, we don't lose anything. And moreover, I would also observe that if we consider the changing trends towards punishment in general, as introduction of juvenile code, probation system, parole and reformation of criminals in prisons, and the rehabilitation after the release from the prisons, it appears that the days are not far off when capital punishment will not find place in our penal codes. It is reflected by the exceptional till final abolition. Now, there was a case a long time back in Agra. The trial concluded, the person was being sentenced like maybe to be hanged by neck till his death. Immediately, the information came to the court that the persons who are being tried for a murder of a particular lady, she is alive, and the police is going to produce her before the court. So this is a case of mistake. So sometimes, to our is human, a mistake can also be committed. Therefore, in view of this also, I feel that it should be abolished. So gentlemen, now it is up to you. I would like to give your own views with regard to the abolition in view of what I have narrated, in view of my practical experience, or to retain it. Thank you very much. Now over to my brother, Justice S.T. Anand.
Thank you, Justice Bhalla. After having covered every possible facet of the roster, thank you so much for handing over the baton to me, leaving me just wondering about what to say. A very meaningful flow of information came from Justice Bhalla, and viewers must have got both sides of the picture. The efficacy of the justice delivery system, or say the criminal justice system, is the foundation of success of a democratic country. We have been hearing about a sense of glee whenever an encounter takes place. There are accusations that the encounter was fake. We are not on that. That is not our roster for today, particularly when the matter is being inquired into. But the very fact that there is a certain amount of glee in the air itself shows, honestly speaking, that at least some sections of society do not have complete faith in the efficacy of the justice delivery system to deliver justice, to do justice. I would not agree with that feeling. At the same time, everybody is entitled to have his own views. Now, back to the roster. If we go by the Indian stance, the governmental stance, it has till date been in favor of retention of the death penalty on the statute book. 2007, when a UN General Assembly's resolution was moved, India opposed it. 2012, there was another draft resolution by the General Assembly it was opposed. At the same time, in the year 2015, the Law Commission did recommend to the Government of India to abolish the death penalty. Till date, the competent court is at the Government of India. They haven't taken a decision. The award of sentence or the proportionality of sentence has absolutely determinative bearing upon the society. With a view to give you certain inputs to be able to decide this way or that way, I'll quote certain instances. Before that, I must indicate that it's not that in every case one murder and death penalty would be recommended by the sessions or confirmed by the High Court or the Apex Court. It's not in every violation of a female that likewise death penalty would be awarded, recommended for being awarded and confirmed by the higher authorities, higher courts. Each case would have its own facts. When the courts, when I say courts, I mean the trial court, the first appellate court, the High Court, and then the Apex Court. They find in a view of concurrence that there was a certain amount of perversity, cruelty, propensity in the commission of the crime. It is then only they would consider awarding or confirming death sentence. I would refer to certain cases. You would remember the Geeta and Sanjay Chopra case in the year 1978 or so, famously known as Ranga Bhalla case. They were executed ultimately in the year 1982. See the propensity with which their brother and sister were murdered. And before murder, the person of the girl was violated. The moment they came to know that they were children of a naval officer, they decided to do away with them. Go to 1990, the Ranjay Chatterjee's case. He was a security guard who raped and murdered a 14-year-old girl in the Calcutta residential complex, one of the residential complexes at Calcutta.
So probably at your back, some speaker is on that's creating some hindrance.
I'll check out. Holmes, मम्मी वो उसके बाद आ रही है, उसको रूम में ले लेना. No, let's go to the year 2008. Salim and Shabnam, they were convicted for killing 7 members of the family in Amroha, UP. That was a case where the total family was annihilated. La Punya case in Haryana, where daughter of the family in connivance with the boyfriend did away with practically the whole family. It doesn't end there. Afzal Guru's case, 2001, when there was an attack on an institution which is the highest on the legislative side, the parliament. It's a very well-secured environment, obviously, because the lawmakers sit and function there. So there was an attack on the Indian parliament. Yaqub Menon's case, 1993, Bombay blast case, where he, with a view to help his brothers, he financed the visit of as many as 15 people to another country to get training in the operation of the firearms. 2012 brings us to the Nirbhaya case, the Delhi gang rape case. A 23-year-old physiotherapy intern was, she got into a bus with her male friend. The conductor, the driver, and some other friends of theirs, they raped the girl, belabored the boy, and threw them on the road. And it's not a pure simple case of rape. It's not a case of, may I use the word simple case of gang rape. It's with the purpose that I use the word simple gang rape. Not only that, the gang raped the girl, they mutilated her organs. They took out her intestines. 2 blood-stained iron rods were recovered from the bus. And they played havoc with the private parts. They were thrown out of the bus. It is an altogether different facet. That there were people, passers-by, who went by that side in cars, had a look, but still nobody stopped. Somebody stopped and informed the police. Well, that again is not a part of our roster. It provided food for thought for a BBC documentary, India's Daughter. It provided food for thought for Deep Mehta's movie, Not Me of Violence. Well, they got the stories. But see the propensity with which not only the girl was raped, the way the God-blessed anatomical features were twisted. Now, apart from those cases of that level, I had been on the criminal roster in the High Court for quite some time. We came across a matter where a mother, in connivance with her paramour, killed her own children. Her husband was living. He had to go to a neighboring district where he had to work throughout the week, and he will get back on the weekend, Saturday. He had 2 grown-up sons. They were in a position to inform the father that so and so comes up to our house in your absence, that he gets cozy with our mother. There was a fair at the village. She, just to, in a way, make believe affair, she asked her husband whether he would like to come to the fair. He was not in a mood. He would have liked to spend some quality time with his wife. He says, no, all right, I will come little later. And she left for the venue of the fair with her 2 sons. They were joined by the paramour. On the return journey, she gave poison-laced chocolates to her 2 sons. They died. I'll put the matter short, then the dead bodies were recovered and they were tried. We had heard of an estranged wife, equally unfortunate, doing away with her spouse, and vice versa also. But it's a rarity to find a mother or a father, in this case a mother, doing away with her own children. The bench of which I was a part also dealt with a matter where a brother raped his own sister. Their father left the house in the morning. His wife was not living. She had gone to the maker and left a word with his daughter that she would bring lunch to the fields. Her brother was in the army and he was on leave. When she didn't reach the fields, he came home, and when he opened the door, he found that dastardly act being done. Punyam murder we had just talked of. Girai triple murder case where 2 sisters, one was single, another had married and had 1 male child. The collaterals wanted to usurp the property of them. They murdered both sisters and the husband of one of them. The child could save himself by mixing in the crowd, and he was the only witness of the crime. Then they put them on the cow dung cakes and set that heap of fire in full view of the village. So you can imagine the propensity and the sense of fearlessness which they had in their mind, as if they could get away with their crime just with the view to get the property. So that's not relevant. What is relevant is what they did. There was a particular fair-minded district magistrate who directed the local DIG to get an FIR registered. That the Director Commissioner got transferred the next morning. Again, I would not elaborate because that will be beyond the roster. The recent Chennai custodial death of father and son is too recent to be even mentioned. The division bench of which I was a part, I said, also dealt with a Badurgarh serial killer. He would catch hold of the minor girls, rape them, and murder them. That shows the propensity that he would like to ensure that there is no evidence left to nail him. But law catches up with the crime by and large. Except perhaps those who go overseas, and our agencies find it difficult to get them back home. Well, things are in process, and we hope and trust the efficacy of the concerned agencies to get them back and to face the music. It won't be very long when they face the law. Nithari mass murder case, not many people killed, and their carcasses were found, their heads were found, their organs were found. You must not have forgotten the Bulandshahr massacre, the UP murder case where a person in authority at that point of time, now he is incarcerated. That's the efficacy of the justice delivery system. He tried to even do away with the witnesses. Perhaps was able to get away with one, but not with the other. So these instances tell us that there are people who would not only like to commit the crime, but would do it with a certain amount of noticeable and despicable propensity. Now please see, when we sit down to frame the laws, the penal laws, the legislators cannot afford to go by emotion. We do not belong to that setup where they would say, eye for an eye, maim the man if he has committed pickpocketing, if he has touched a female, if he has raped a female. We are not on that. And we don't have to examine why we are not on that. We are a society based upon interest in culture. We know what our Indian culture has been and is. At the same time, there have to be laws to put people in place, to put the criminals in place, to put their mindsets in fear. The mere fact that some people would not fear law, it doesn't mean that the law would not ultimately catch up with them, or that we should not have hardest or harshest penal laws in place. Normally, when there will be people advocating the abolition of death sentence, they would say there is no data that it would lead to the reduction in the rate of crime. There is no data either to suggest that if it is not abolished, then what will be the data? So, making a mention, making a submission, or making a suggestion without any data is neither here nor there. We have heard that they say it is used only against the poor. This would be a very uncharitable comment upon the justice delivery system. If the rich if the influential do not get caught, would you blame the justice delivery system? No. You have to bring up the quality level of the investigating agencies. You have to bring up the quality level of the prosecution agencies. I remember maybe in the mid-80s there was a suggestion, and let me not be misunderstood that I'm advocating that this should be done, but on point of fact, there was a proposal that a district judge should be put as director of prosecution. I remember that. I would allow me to refrain from mentioning his name. But the proposal went through. Why I say is, if the investigating agency is independent of any control by the authorities, it will work independently. It will not be under the influence of the police, although they themselves will be part of the police. Then whatever lacunae are left in the quality of collection of evidence, a public prosecutor would make a suggestion, effort would be made to locate acceptable evidence in terms of law. It's not that he will have to look up to the local police chief for instructions. It's not that he will have to look up to the district magistrate for any guidance. No, he would be independent. I may not be taken to suggest that everybody these days gets instructions or obeys instructions. I'm only talking of an ideal scenario. I'm not at all being accusatory. The decision in the relevant behalf has to be taken by the competent authorities. When we deliberate, we make our presentation. The consideration has to be done by the competent authorities. Our job is over the moment we share our experiences or thoughts with them. There is no obsession with that. So it is not fair to say that the law catches up only the poor. I heard a statement that the application of death sentence is arbitrary. Allow me please to differ. There is no data that it is being applied arbitrarily. I can quite agree that since every honorable judge would have his own mindset, his own prism from which he would have a look at the facts. At the same time, if there is a trace of streak of perversity in the circumstances, surely identical view would be taken and has been taken. I'm not in the know of any particular instances, much less frequential instances wherein anything may have been done arbitrarily. It's not that way. I would not agree. Then it is very frequently said that the possibility of an innocent getting hanged cannot be ruled out. Yes, my learned brother Justice Bhalla made a mention of one particular case, I vow. But see the nature help, and the man was saved. The citizen in us, each one of us, the human being in each one of us would feel happy. But the number of such instances would be hard to be multiplied. There is no multiplication of such instances. When I make that submission, kindly see the value which we attach to a life, human life. And please appreciate our hierarchical system of justice delivery system. The trial is conducted by the Court of Sessions. The recommendation for confirmation of the death sentence is made to the High Court. It's an automatic appeal. It's heard by a division bench. If it is, whether it's confirmed or not, that is the judicial decision of the bench. Then the convict has the option to go in for an SLP, where it is heard by two judges of the apex court. There is a sense of dissatisfaction with the verdict delivered by the SLP bench. The reason for review is there. Still, if the conscience is not satiated, we have a provision for curative as well. Thereafter, we have a provision in the Constitution itself for the mercy petitions also, and a number of mercy petitions, as my learned brother Justice Bhalla mentioned, a number of mercy petitions were accepted by the President of India. So that provision is also there. So it will be very difficult to accept that there is any possibility of an innocent getting hanged. The level of value which we attach to human life can be seen from the fact that we have had in not very hoary past, probably about 2 pre-dawn court sittings in the Supreme Court, where the review pleas by the convicts on the death row had to be heard. That's a compliment to our justice delivery system. We value a human life, but we must also take into consideration the condition of the victim, the ordeal which the victim of such dastardly crimes undergoes, the ordeal which members of the family of the victim, I would talk in gender neutral terms, whether it's male or a female. Take, for example, in the case of the Nirbhaya, see the life which her parents led. In spite of that, the law was very indulgent in not denying to them whatever remedies were available to them, whether it was on one count or another count. There were accusations in the air that the law was being indulgent, but the law can take on that accusation. But fair trial and observance of principles of natural justice and observance of the fundamental principle of the constitutional documentation must. And we did it, and law did have its own course. If the society or any part of the society feels dissatisfied, that's a reflection of the justice delivery system. There have been many instances where somebody prayed for commutation of sentence on a plea that he was a first offender, a first-time rapist, a first-time member of a gang which committed gang rape and murdered the victim. And that his behavior post-conviction had been excellent. This plea was declined, and rightly so, by the apex court. Recently, a 3-judge bench headed by Justice Bobde held that no, this is not a good ground. There have been instances where there was exceptional delay in the disposal of the mercy petitions. Years were taken for disposal of petition, and certain number of commutations did take place. It's time the competent authorities prioritize the death row convicts mercy petitions. There must be other mercy petitions also. These should be prioritized, red flagged, and put up before the president of the country for taking a decision in terms of the rules of business. But the fact that there is delay in the disposal of the mercy petitions may not appropriately be held to be per se a ground for commutation of sentence. The law keeps on evolving. These legislators keep on making endeavor to make changes in the law. Recently, the committee has been formed by the Government of India, Ministry of Home Affairs, for suggesting improvements in the criminal justice system. On point of fact, there is a variation of view about the constitution of the committee, but I'm not on that because that is not the roster of today's discussion. Law Commission is there, and the committee will also make some recommendations. Law must put down the desperados with a strong hand. We have had cases where the people, certain assailants had the atrocity of entering the courtrooms and killing people there itself. I have before me a news item appearing in a national newspaper where an incident occurred in the court of Chief Judicial Magistrate Meerut courtroom where an accused was being tried for the murder of a local political leader and his nephew. And there were a third accused as well. 3 gunmen entered the courtroom while proceedings were on and fired. 1 died, others were perhaps hurt or they escaped. Now this is there. Then, and it's not that the law is harsh for everybody. The law does take notice of the aspect of juvenility, and there have been well-reasoned indulgence on the part of the apex court by saying that plea of juvenility can be raised at any stage of the proceedings wherever both have been. Certain changes have been made and might be considered in future to determine whether a juvenile proved to have been much more conversant with the anatomy of a female, even at a young age, whether he should be treated as an adult. There has been an instance at Gurgaon where a juvenile court treated a juvenile as an adult. The appropriate rule will be taken by the High Court, where perhaps the appeal is pending. My experience as a 4th-generation lawman, whatever I heard in legacy and whatever experience I had is the capital punishment must stay on the statute book. And let there be no misgivings. Its being on the statute book does not mean that it would be obviously invariably inflicted in each case. As I said earlier, in the rarest of rare cases. Before ending, I'll give a small example. If you permit me to draw the parallel. When there is a flock of cattle being carried along by someone, he would carry a stick in his hand. He would not hurt the cattle. The cattle would know, yes, there is a stick, we have to proceed straight. People, the perverse mindset in this society must know the efficacy of the law. Excuse me for the comparison. Idea is that fence sitters must have this fear instilled in their mind that law will catch up with us. In the recent past, there have been instances where there were instances of arson, of loot, but law did catch up with them, and sooner or later, justice will be dispensed to them. My submission, categorical submission would be capital punishment must stay on the statute book, and as citizens, we must trust the efficacy of the justice delivery system to do justice. Thank you so much. Thank you so much for, shall I say, patient hearing. Thank you. Over to Vikas.
Sir, we are unmuting Justice Bhalla also. Justice Bhalla. So the facets given by both of you are in fact quite thought-provoking. And the way both of you, and what I said at the first instance, that we have always, as a student of law, learn from you the way you have given the entire law, the legal platforms, what are the recourses from the districts to the High Court and Supreme Court. And the another beauty, while both of you were on the platform, was that what we say in the law parlance, it's commonly said that we may agree to disagree. The disagreement on a particular note could be for limited aspects, but as they say, the lawyers can disagree within the courtrooms, but outside the courtroom, they are the best of the friends. And the classic example is today that we had a different thought process. But Justice Bhalla, remembering that it was your birthday, it shows that you, I will say, you are sinking deep in his heart. And on behalf of Beyond Law CLC and all those participants who are here, belated birthday wishes. And they always say that the belated wishes are the best one because they are more in isolation. And in today's arena, though nothing to do with Corona, because but they carry more value because they're lesser in number. People does remember that who has done. But today we can say that we are just like bunch of flowers, or rather a valley of flowers. All wishes coming together to wish you for your best of the health. And the way you explain, both of you, the justice delivery system has been quite fascinating. Till now, we have one question when we can take the questions further forward. But Justice Bhalla wanted to give his insights before we take questions from Abhilasha. And meanwhile, the other participants can always post the questions on the chat box or on the Facebook since we are live. These questions can be always be taken. Yes, sir, Justice Bhalla.
Yeah. So I just wanted to find out all those people who have joined, what is their opinion with regard to the abolishing or retention?
So they can post it on the chat box and
Yeah.
we will give it. So meanwhile, Mr. Abhilasha Bhatia says, does public opinion impact or affect in any way the decision of awarding death penalty? He means to say that we have quite often seen that there are certain issues which are actually boiled up through the social media, print and electronic. They want to ask, since you have been on the other side while the delivery system, does it affect, because in common man, and this has been a debate, lot of debate, that whether such issues should be there or not.
You see, I have to reply.
So anyone, then the other could buttress.
You see, it does not affect in any manner. You see, there's hardly any effect on the judicial side as far as the public opinion is concerned. The public opinion which I referred to was for the sake of amendment. If suppose IPC has to be amended and something has to be done there in it in order to dilute this section, then in that reason, public opinion would always be taken so that people may not oppose it. Like, for example, in Parliament or when the bill is being passed. So they are in Parliament, they are the representatives of the people. So if public opinion, if they carry with them, then the things can proceed. Now, with regard to this retention and abolition, I would also like to add one thing. Even if has to be retained, it can be diluted. In certain cases, like Brother Anand referred to Nirbhaya case and many other heinous cases, their death sentence can be retained. But there are certain cases where ultimately the Honorable High Court or the Apex Court then converts that death sentence to life imprisonment due to certain reasons. That is only because of those factors. So if it has to be abolished, it may not be abolished in toto, but at the same time, it can be diluted in view of certain offenses which are being committed. Yes.
I add something to it?
Yes, sir. Yes, sir. Definitely.
Vilasha, the presiding officers are as good human beings as others are. I can assure you. But the very fact that the presiding officers, judicial officers of the courts, the High Court or Apex Court included, have to document reasons for their view. Whatever appears in the press might agitate you for a moment in the mind. It cannot, I assure you, and it does not affect your judgment. It does not affect your judgment. Let there be no misconception in the mind of the public, or even the media, I should say. Media trials take place. People criticize, people support. We are not on that. But the judgments are delivered with a cool mind. With a cool mind. It doesn't affect the ultimate outcome of the trial. That I can assure you, and Brother Bhalla will bear me out. While handling such cases, it's not that our minds did not get turbulent, because you will always have two sides before your mind. When you sit down to deliberate, you will say, oh, this is what is proved to have happened. This is what is proved to have been done. Then the judicial mind will relate it to the evidence available, evidence acceptable at law, not the evidence appearing in print, not the evidence appearing in any inflammatory speech at any platform. The judicial mind will look for it within the file and form a view. So it's a cool mind which deliberates. Our assurance for that. Yes, please.
So we have Mr. Mehta, who has been a session judge, and he's doing extremely well as a professional. He wanted to give an insights, firstly, since he has been on the judicial side, and what he has taken the cue from the today's session. Mr. Mehta. Mr. Mehta. He is unmuted, but we are unmuting Mr. N.S. Nair. Meanwhile, Mr. Mehta joins us. He wants to post a question. He has posted a question. Mr. Nair. N.S. Nair. It's an email ID. Okay. Mr. Nair, either you can post the question or you can ask the question directly. So, Mr. Mehta is there. Mr. Mehta, you can give your insights. No. Mr. Nair, the question here. Mr. Nair, at least I have not been able to read your question. You said that you had posted the question earlier. Could you read your question?
Okay.
Mr. Nair is already. Mr. Nair, you can ask the question directly.
Achha, my question was that when more than 100 countries, they have abolished the death penalty, and they are modern and progressive countries. So they are not feeling any negative impact of abolition of death penalty. Why can't our country, India, follow suit and abolish death penalty, instead of retaining the death penalty?
Law is not anything abstract. There is nothing abstract in law. Each society, each country will have its own circumstances, its own mindset of people. India has own peculiar mindsets of citizens. If every law were to apply to every country, we could have borrowed law from a country and applied it to us. No, it's not that way. The laws peculiar to a particular societal environment are different. And I think as a nation, it's not necessary that we also abolish. When I've said there are enough checks and balances, enough checks on the exercise of that power. I hope that satisfies your query. Thank you.
Yeah. Thank you very much.
So this is by Azad Singh. No, Mr. Mehta is unmuted. Mr. Mehta, your insights.
Good afternoon. Am I audible? Some problem?
Yes, perfect.
So, hearing both of the lordships, the only impression I gather is that yes, what we were doing all through is right. The penalty has to stay on the statute book, but just because it is on the statute book doesn't mean that in each and every case it is being so awarded. It has to have a deterrent offense. The offenders must know that it can lead to capital punishment. Otherwise, in my 16 years of career, when I could have, there were a lot of situations when for a moment the mind thought, yes, it is a fit case for capital punishment. And there were 4 or 5 days of intense wandering within myself. And in my 16 years, I did not award even a single death punishment. Still, despite my views that it should not be awarded with light mind in routine, the punishment must remain on the statute book. It has deterrent effect.
Thank you, Madhava. And so, Mr. Azad Singh, I will ask Justice Bhalla to give his insights, and then we will ask Justice Anand to give his flips also on that. Azad Singh asked, nowadays police officers are having mindsets of bypassing the law and doing justice on the spot, including fake encounters. Please suggest how judiciary can protect the rule of law and faith in this country. Justice Bhalla, since I thought let's have the opinion, since he had also been the acting chairman of the Haryana Human Rights Commission.
You see, before parting, that was in my mind to request Vikas.
Yes, sir.
That the next, whenever you want to do it on encounters. And then, you see, on encounters, let's not call it fake encounter. How we can say this is a fake encounter till we have gone through it, we have gone through what the circumstances are. Encounter is an encounter. In what circumstances it has been carried out, we only gather from the media only, and then we feel it is a fake encounter. The question is, even if the judicial inquiry is there, sometimes the evidence does not come forward to that extent. Reason being, I am straight outspoken, because the state government wants that the inquiry should be in such a manner that it should be in the favor of the government. So the question is this, as far as the encounters are concerned, it is a very important subject these days, and we have to go deep into it. Just by one question, we cannot arrive at a right conclusion. So you can have sometimes on this encounters, then we can gather the statistics and we can gather so many things and then point out everything.
So point well taken. As they say that whenever there is there can be serial killing. Like serials also, they say that today we can just have the curtain raiser on that aspect, and then yes, of course, the point well taken from your insights that we can definitely have a discussion on encounters, because this is one of the burning topics. Because in the lighter way,
these days.
Yes, sir.
These days.
Sir, that's why in a particular one of the WhatsApp message was quite widely spread when the sannyasi says that I should go walking rather than taking me in the vehicle. बहुत जल्दी पलट जाती है.
That's right.
5 किलो कर दियो 5 किलो कोड़े पाया.
Yes, sir.
Yes.
No, because the pakora's flavor went on public, so we thought that first we would have to.
No problem. No problem. No problem.
So that's the flavor of the virtual platform. You can actually, you can't smell it, but you can actually hear it. That's the flavor. Right. In the audience, you can't do. In an auditorium, you can't have that.
Yeah, that's right. So
yes, sir.
Even we could have asked Justice Anand to do the same thing on account of his birthday.
We could have a virtual cake ceremony.
Yeah.
And fortuitously enough, we have his daughter, Guinea, and his son-in-law, Jagmohan, also joining on the platform. And in fact, his brother-in-law, Mr. Manor Lal, had also joined. I all know this because they are from our same fraternity. We will be.
Yes, I also know them well, right from my young old days.
Because you were talking of, Justice Bhalla says they hold a webinar on encounters. You can consider inviting Nana Patekar for that.
Pardon, sir?
You can consider inviting Nana Patekar also for that. But I can tell you,
yes, sir.
I come from a judicial officer's family, my father used to share with me certain peculiar difficulties which police people face in the matter of investigation. And he also used to share with me the extent to which certain unscrupulous people could act. It's a medimix. We will always find good people, and no citizen can approve of a fake encounter, proved to be fake encounter. Law will have its own course. I repeat, if it is proved to be a fake encounter, if it is not, of course, the law
That's
will
true.
ultimately catch up. Whether you can smell the pakoras or not, law will catch up. Don't worry.
That's true. Ashminder Kaur says, as it is often quoted, when a man kills, he breaks the law. When the state punishes by death, it upholds the law. What's your take if instead of giving death penalty, a provision of imprisonment for years more than a human life is awarded, like 100 years or more, as it isn't done in US and some countries?
You see, the answer to this question is, I have already discussed in detail that if a person is given life imprisonment till his life, throughout life, till his natural death, I think it is more than 100 years. Every day he'll be dying, and he might live for 90 years, 98 years. So that is why I say, if it is abolished, then it should be life imprisonment till his natural death.
Anand Saab.
I could not get the question. Would you please repeat the question?
The crux of the question is that instead of life, this death sentence, if in US they award human life, the imprisonment for years more than a human life, like 100 years and more, as is done in US and other countries. What is your take on that?
No, the beginning of the question was slightly different. Beginning of the question.
So that was it is quote. It says, as it is often quoted, when a man kills, he breaks the law. When the state punishes with death, it upholds the law. That is her quote.
Yes.
Yes.
This is the reason. The state does so to uphold the law. The state is the repository of faith of citizens. A citizen or a criminal or even other person, he is not supposed to take law into his own hands. State is under a constitutional responsibility to administer law and order. So there is a clear distinction between what a state does and what an individual does. However justified, a man cannot be allowed to take law into his own hands. That's the only distinction. The rest of the question Justice Bhalla has explained. Yes, please.
So this is by IP Singh on the Facebook. He's the president of the DRT bar. He says, meanwhile, I will take yes. IP Singh says, in countries where punishments are harsh, the rate of crime is less. So death penalty should be retained. That is his suggestion. Life imprisonment should be executed till death, which can also partly serve the purpose of. What's your opinion?
We have already given this opinion in detail. You
Yes,
see, this should be diluted. 302 death under 302 death sentence should be maintained, but it can be diluted. That for waging war, okay, fine. For heinous crimes like Nirbhaya case, okay, fine. But whereas in other cases, it should be, I think it will be more deterrent, it will be more torturous if it is life for life. Why in America it is say 100 years? Because they know it, nobody can live beyond 100 years. So here amendment can be made that life till his natural death, the person will remain inside. So instead of death sentence, the man goes within 5 minutes, 10 minutes, after 5 years, 10 years, he is executed. He doesn't realize anything. Rather, he is clear of his sin, you see. So
we have been granted that. We have been doing that. In a serial killer case, we awarded life imprisonment.
Yes, that's right.
Till death. In a recent gang rape case from the state of Punjab, they were sentenced to life imprisonment till death. Retention we would always advocate as individual, as lawmen, retention. Because if it is retained, it can't be retained on only for particular offences. Retention by the lawmakers, courts will only actually interpret. Retention is a must. Application in required cases, and we must trust the wisdom of the courts up to the apex court. That's it.
Before we take the question which Mr. Krishnan, Siv Ramakrishnan has posted, I would just like to apprise that Honorable Mr. Justice Vinay Mittal is watching you since of your knowledge on the Facebook. So greetings to Justice Vinay Mittal and Sangram Saro again, and Rajkumar Chok with Paramjit Brad. These are the few names which I've been able to catch up on the Facebook. They are watching us live. Krishnan Sivakrishnan, is there any way to de-link the criminals investigation by police department and create separate department for criminal investigation to avoid police beatings and to avoid custodial deaths? The police should only be given the power to file FIR and then pass it to another department.
Meaning thereby that you want that there should be a separate investigating agency. This is what he says.
Yes, sir. That's what
this is what I gather is that he should say then police will do what? For example, if the investigating agency is separated, a crime is committed, for example, in Sector 17, a case is registered at the police station in Sector 17, then the investigation, if goes to another investigating agency, then what is the role of the police in the country?
May I intervene? May I intervene?
Yes, please do that.
Brother Bhalla, like in the NDPS cases, the law of the land by the apex court is that the police official who makes the recovery will not investigate the case further. And if it does, it is invalidated. So likewise, I think the questioner has a foundational base in suggesting, and it can be considered, that the FIR is registered and the matter goes to an agency which is independent of the police. It's time, we are heading for those times when the citizens are going to ask.
Then the police is not required. And for every small theft case, you say investigating agency. For a small stolen article, investigating agency. What has to police is not meant only to register a case. The only thing is this, that police agency should be streamlined. There should be such measures that they should not be able to do any hanky-panky in the investigating agency. And it can happen only then that an investigating agency as a part of director can be manned by some other people apart from the senior IPS officers or all that, who can look into the matter whether the investigation is being done in a proper or fair manner or not. Otherwise, if we come to this conclusion that police is not to do it, you see, purpose in NDPS Act is entirely different, because there were a lot of cases, instances, even to my knowledge also, while I was trying those cases, that it's a case of plantation. Somebody wants that this person should remain inside, he will see that the opium is planted. It was because of that a gazetted officer should be there, and it should not be that investigating agency. But in a case of a murder, in case of a heinous crime, there's no question of any plantation. So police is not to sit idle. The only thing is this, some independent person, maybe like you suggested, a district judge as director of the prosecution. So similarly, with the senior superintendent of police, the government can appoint such a person who should be an independent, has nothing to do with the police or with the investigating agency, and he should supervise the things. This is what my opinion is.
I can agree. You see, the Prakash Singh Committee recommendations on police reforms. Prakash Singh Committee recommendations on police reforms have not been for one.
Even National Law Commission recommended regarding this abolition of death sentence, and I have the figures when it was debated thrice in the parliament, but it could not be carried out. So various reasons. Now, number of countries, they have abolished it. I have a list of those countries. Due to shortage of time, I didn't touch that point. There are so many countries. I've got a list of those countries who abolished it. I only mentioned New Zealand because they abolished it and then they revived it due to certain
Mr. Himanshu Kanda says, according to my viewpoint, a major role played in entering any crime is poverty. Many government schemes are going on by the state as well as by the center, but it's not working in some manner. What's your take? Yes, sir.
The former acting chairperson of the Human Rights Commission.
No. What is the question? Is that certain?
So he says that majority of the crimes is because of the poverty, and many government schemes do not actually reach to the person in the right way. What's your take? Because he says because primarily poverty is the reason.
You see, even if those schemes are not there, number one, as far as the poverty is concerned, you can't get out of it. You see, why go far off? During this lockdown period, a small theft crimes have increased just because of this reason, that the poverty is there. As far as the schemes are concerned, you see, when I was in the human rights, there were a lot of applications used to come to us that such and such scheme is there, that they will give ration to such and such person, and the sarpanch takes everything and it doesn't reaches the man. So there, of course, whether it is human rights or whether it is judiciary, if a complaint is filed, it can be looked into it, and a direction can also be issued in a public interest litigation to the government to implement that in a just and proper manner. That is the only way out. There's no other way out on this.
And it can be done. It can be done. You see, schemes, well-meaning schemes are in place. The question is how best, how immaculately, how honestly are those being implemented? Schemes come from the government. Fair enough. The implementation has to come about at the administrative level. The local deputy commissioner, the local SDM, the local tahsildar, the local patwari. Now that we are in an age of computerization, I'm neither for this or that or against this or that. There has indeed been improvement in the sense that the benefit of schemes has started reaching the quarters for which it is meant. Not 100%. If few people have got cylinders, they have got it. Earlier, they were not getting it. The poor people. But maybe larger number of people have not got it. For that, you have to make a well-oiled, accountable, administrative setup. No fault with the policy. Funds are allotted, policies framed. If public servants do not, or if it is found that the public servants are not effectively or honestly implementing it, can't blame the government. It must reach the poor. Ours is a vast country. It might take long, but we must make a beginning. Beginning has been made. Public should be alert. The NGOs should be alert in watching. They should watch the conduct of the public servants. Yes, accountability has to be fixed. Accountability was not fixed till recently. No, it has started. The accountability is being fixed. And there is no dearth of well-meaning public servants. So please ensure the competent quarters that the benefit of each scheme reaches the individual for whom it is meant, and whosoever impedes the disbursement of that benefit should be punished under the law. Punished. Then only 10 years down the line, 20 years down the line, things will improve. There will be no poor. Or maybe when we come back after undergoing that 84 lakh yoniya, we will find that ours is a much healthier, less poorer country. Properly implemented schemes, benefit must reach, I agree. It's for the competent quarters to ensure that the benefit reaches. Yes, I quite agree. Thank you.
So thank you. And probably just as Justice Bhalla had said, the generator also couldn't generate the amount of energy which he actually possesses. So somehow he has left the platform. Be that as it may, he will be connecting us on the Facebook. So the session, as we at the first instance and at the first brush said, that we would definitely be enlightened. And needless to add, I, on behalf of Beyond Law CLC, as well as the participants who have shared with us on this platform, coupled with those who are on the Facebook and ultimately will watch us on the YouTube. We thank everyone. But before we part, one on behalf of Beyond Law CLC, and my elder brother Shri Ashu Punshi has been appointed as a public prosecutor Chandigarh. So on the day when we are discussing on the criminal law, the congratulations to him, and his predecessor also performed the duties extremely well, Mr. Randeep Rai. So congratulations to Mr. Rai, who performed the duties so well as a lawyer, as a officer of the court, and Mr. Ashu is again. I would just ask Mr. Anand to say, since he has also seen Mr. Ashu Punshi as a lawyer, and then for tomorrow, before that, sir, only one line I will share. Tomorrow we have, in our pursuits to of the webinars, tomorrow we have the former Chief Justice of Bombay High Court, away from courtroom battles, way forward. And we thought this could be the best time during the lockdown, that can there be way forward? And tomorrow we have Justice Mohit Shantilal Shah, former Chief Justice of Bombay High Court, and who had not only been a lecturer, but in a part-time college. He has been a Justice of Gujarat High Court, Calcutta High Court, and Bombay High Court. So his knowledge, his insights tomorrow do stay connected with us. And thank you, everyone. And Justice Anand, before we part.
As you see, while congratulating the new appointee and wishing him all the best for his further innings, you ask the viewers, it's a deliberation. Nobody is here for this view or that view. The viewers must share their views. It is the views at the ground level which would help us have better laws, more practical laws. They should not fear. They should share their views without venom, without sounding accusatory. If they do not share, then how do better laws come?
So they will connect with us on our WhatsApp number. They all know that since we have a WhatsApp group, which
I can assure you that when
Justice Bhalla is there, I'm just taking his expressions. He is connected. You can.
Good takes place, the name of Vikas Chhatr will be mentioned for having facilitated these large-scale deliberations. I'm sure about that.
Hello. Yes, brother. Okay. Hello. Hello. Can you hear me, Vikas?
We need your concluding take. Vikas is requesting you for a concluding take.
There is some, there was some problem, na? So that is why I rang him up. So can you hear me?
Yes.
Hello, can you hear me? Hello, Vikas? Okay.
Sir, we are able to hear you. In fact, I was muted down. He said the host thought when Justice Bhalla is speaking, I should be muted. Yes, sir, we are able to hear you. Unmute Sunil Kumar. Sir, we are unmuting Mr. Sunil Kumar. His spirit to remain connected shows himself. Bhalla Sahab, you will have to unmute yourself. Sunil, kindly unmute yourself. Sir, you will have to unmute yourself.
You have not done it?
Sir, आ गया आवाज गूंज रही है. Yes, sir.
Yes. What is your question?
Sir, now what has happened at Yao Place? There are two mics on. Just keep one mic off. Otherwise, the voice is cracking as well as it's echoing. Sir, पहाड़ियों की याद आ गई.
उन्होंने मेरे
सर जस्टिस भल्ला वाला माइक ऑन करना है.
You switch on Justice Bhalla mic.
Okay. You're logged in?
Yeah.
Yes, sir. We are unmuting you, sir. You will have to unmute yourself. Bhalla Saab. So, Mr. Sunil, unmute Mr. Bhalla on that side. Yes. Bhalla Saab, unmute.
Okay, yes.
Sir, एक माइक बंद करोगे नहीं तो इको चलती रहेगी. Yes.
Done it. I don't know what's gone wrong.
Now speak, sir. Bhalla Saab, अपने आप को unmute कर लो.
Hello, sir. You are unmuting Sunil Kumar. You are not
particular-
unmuting Justice Bhalla.
Justice Bhalla को unmute.
Okay.
Okay, fine.
Yeah, now it's
Yes,
okay.
sir.
Yes.
Yes. Yes, sir.
Anji sir, what is your question?
So, now we were on Justice. We had concluded. Justice Anand was saying that the participants who have participated not only on the Facebook but also on the platform, they should actually take things forward after taking insights from two speakers who had their practical knowledge of the on the other side and how it can be suggested. More so, I take further step that since the Law Commission and the members are already looking into all this thing, that the participants should actually tell what is their take from your suggestions and their independent suggestions. That is Justice Anand's suggestion that that's the best way to move forward. And since perchance you were not there, we had apprised the participants that tomorrow we have a webinar by the former Chief Justice of Bombay High Court.
Yeah, I heard that.
Away from courtroom battles, way forward. Yes, sir.
Yes.
So, what is your take before we part for the day, and we will be connecting tomorrow? Yes, sir. Bhalla Saab, aapki suggestion.
Alert from Google Chrome.
Hello.
Organize
Yes.
your book collection, stack of books.
Sir, Justice Anand का लगता है वो mobile. Yes, sir. Yes.
So yes, you want my suggestion on what intake? Like
Ultimately, the
this today-
conclusion part, like Justice Anand concluded, what is your
Yes.
take on that?
Yes, my intake is on this is I earlier also I said so. Now you have heard both of us
Yes, sir.
on abolition and as well as on retention. What
Yes.
we'd like, I would like is that on the Facebook or otherwise some suggestions, those who have heard us, they should tell us what are their views about the abolition and the retention. in
Right. So
one line.
we have said that they can post me on the WhatsApp. Everyone knows my mobile number. I will
Yeah,
share it with both of you in
Yeah.
case any suggestions come.
Yeah, that's right. Thank you very much for this.
So everyone stay safe, stay healthy,
And
and
same
on
to
behalf
you.
of Beyond Law CLC and all the participants who
And
have.
thank you very much for occupying us in this unlock period. Something
No,
to
sir.
do.
The pleasure is all
Thanks a lot.
ours because they say if you are under the lamp, you would always be enlightened, and
All
that's
right.
what when the judge you are with the judges. As they say, whatever company you are in, you always get that type. If you are in a room of perfume, you are automatically to learn something.
Chalo. Thank you very much.
everyone.
So nice of you.
Thank you, sir.
All the best. Have a nice evening. Bye bye.